legislation where there is a direct, non-speculative harm. Those types of restrictions have been upheld when they've been challenged in court. But there's all sorts of studies that show that people who have had an accident, they really aren't in a very good position to be making a choice of counsel. Too much stuff is changing during that time period of a couple weeks up to a month after the accident. But so often, as we saw in the case of the New York restrictions that were struck down, or a similar set of restrictions that have been struck down in Louisiana and in Florida, is that they don't actually do that work to do the studies to try to find the narrowest thing they can do. They just sort of say, well, we think this is a problem, so we're going to prohibit it. And then that relates to the final test, which is probably the most important one, which is that even when they do that, they have to regulate as narrowly as possible. You have to do that study, you have to find what the harm is, and you have to find the narrowest way to regulate it, the least imposition on attorney speech. All very critical points, and all getting to the idea that even when we're talking about stuff that is advertising, the amount you need to worry about it is in proportion to how far the state can go in regulating it. And I realize that not everyone wants to be a test case for your state bar, but you should also realize that outside of a few of these states that are really struggling with this, like Florida and like New York to a certain extent, most of the state bars, I think, sort of get how the extent to which they can regulate and the extent to which the commercial speech doctrine limits their ability to regulate on what would otherwise be very standard forms of communication. It's also interesting in that since the Central Hudson case, there have been some 24 cases at the Supreme Court on commercial speech, and there have been a lot of interesting commercial speech cases just in the last year at the Supreme Court level and at the district court, the circuit court level. And there's been it is a one-way expansion of the commercial speech doctrine. I mean, every single case has expanded the commercial speech doctrine and basically restricted the ability of regulators to restrict commercial speech. In fact, the most recent case, which just came out last week in the Second Circuit in New York, actually overturned a conviction for a drug representative who was promoting off-label use of the drug, which is something that has always been regulated. There have been tons of fines and criminal convictions under that, and basically, in that particular case, the court found that was too much regulation. It wasn't permissible, and it's really an interesting decision. It's still being studied, and I'm sure it will be heard by the Supreme Court within the next year or two. But the overall theme here is that more and more the ability of regulators is being pared back, and